What you are really saying is that, look, irrespective of the numbers game, so to speak, according to you, the speaker could not have been thwarted from deciding the disqualification petition.
Yes.
And second, a trust vote could not be held when the disqualification petition was still pending before the speaker. That really is too.
Those are the 2 points, Malaj. And the governor should not have sworn him in. That's the action of the governor. He could not have sworn in a man, Malaj, who is facing disqualification.
But Mr. Sibal, we also have to go into the wider issue as to whether can a trust vote, in that sense, or should a trust vote be postponed?
Yeah.
Really, because the disqualification petition is pending.
No, Malaj. The question is whether time should have been given to them. It all comes down to 27th of June.
27th, yes, that's the first.
So, Malaj, the trust vote only happened after that, Malaj. Had that not happened, the trust vote would not have happened.
So therefore, in other words, what you are arguing is that the issue relating to 10th schedule must be done later, and what is to be decided is about the status of the party outside the Legislative Assembly, which is to be determined whether there is a split or a dissension in the party as a primary issue. And once that is decided, the question of 10th schedule triggers in thereafter is your argument.
No, 10th schedule triggers immediately, Mother.
10th schedule will trigger immediately.
Yes.
But for 10th schedule, what is to be seen is the events with respect to the political party, not the legislative party.
No. The 10th schedule cannot be subverted by members of the legislative party taking a decision that there is a split in the party.
That is what I'm saying.
Without there being a split in the party.
That's what I'm saying.
Yes.
That's your primary argument, is that.
No, my Lord is saying what I'm saying. That's what my Lord is saying. The disqualification relates back to 21st of June. That's the day, Malaj, that they have to show what is their defense under the 10th schedule. That's the day.
According to you, the speaker under 10th schedule only gives a declaration.
Yes. That's correct.
So whatever has happened after 21st June, it is always subject to the disqualification from them.
That's right. Because it relates back. That's why lordships, 5 judges have held that. Constitutional bench has held that.
So that is also one of the issues which is referred. What will the consequences in between?
That's correct. Your lordship is right. So that's why I've always said, Nabam Rebi and all that has to be decided by lordships one day. All this has to go ahead.
Today, because the applications are pending, complaints are pending.
Yes.
The House is continuing.
Yes.
It's not lapsed by flux of time.
No.
So the speaker is there for the House. Speaker decides today. 10th schedule complaints. It should relate back to.
That's 21st of June. That's correct.
Then in simple cases, we should ask the speaker to decide.
But why ask the speaker to decide, Madam? For the simple reason, I tell your lordships why.
Your other argument that court should decide is a different matter. If the 10th schedule should operate, the complaints must be decided by the speaker prima facie to start with. So therefore, the argument is just this.
Yes, that's your lordship is right.
Decide now, he should decide now. Speaker is speaker irrespective of whoever it is.
Correct.
If he decides, it will relate back.
Correct.
Then in other words, to say that we direct the speaker to take a decision.
The same thing should have happened to the deputy speaker on 27th of June.
Assuming, Mr. Sibal, assuming you are right in everything that you have argued, that look, first the 27th order should not have been passed, that the speaker should have been allowed to take a decision on the petitions for disqualification. What is the net consequence of your argument? I mean, what direction to give the court?
Facts are undisputed. What is the speaker to decide in this? What is the speaker? I want to know what is the speaker to decide. What is the speaker? No. They have not filed a reply till date.
No, but the question is who decides? I mean, the court can't take a decision.
But why not? The court decided. The court decided, in Rana.
Well, the power to decide a disqualification.
They did decide in Rana, 5 judges decided in Rana, saying that we will not send it back. The facts were undisputed. There can be no defense, because under the 10th schedule, there is no defense except a merger. What is the speaker to decide? And then your lordships will say, we can't issue a mandamus to the speaker to decide within 7 days. Then there will be a constitutional issue referred to 5 judges then. Because you can't issue a mandamus to the speaker. Justice Nariman says within 3 months you should decide. No speaker accepts that judgment. Where are we going?
Got referred to constitutional bench.
Where are we going, Maharaj? The point is,
for raising the question, it will require reconsideration of Kyoto.
I'm myself saying so, Maharaj. No, you please, whatever it is. I've said so twice already. It's only a merger, Maharaj. That's not their case.
But, Mr. Sibal, just as you say that, look, on the 27th, the speaker could not have been stultified in taking a decision on the disqualification petitions. Once we adopt that principle, then we have to be consistent and apply that principle across the spectrum. Because there's a very valid point which you are making, which is that the speaker himself is a constitutional, or the speaker themselves, I shouldn't say himself, the speaker themselves are constitutional authorities. Therefore, the speaker has to take a decision under the 10th schedule.
Right.
If that is so, then we have to be extremely circumspect about, replacing the mechanism, the institutional mechanism which has been provided by the 10th schedule itself.
The problem in this case is, Mother, that this is because we perpetuated an illegality. Now the speaker came into existence by perpetuating an illegality. And now you are giving the cloth of authority to that speaker who has actually come into place because by
we can't reinstate the earlier speaker because there we are benching upon the
Upper Arabia you did it. In Upper Arabia you did it. You in fact reinstated the entire government. I'm not saying you should do it, Madad, but if your lordship asks me that question, that's exactly what happened in Upper Arabia.
Sibal, will the court not be getting into the thicket of the entire gamut by virtually clothing itself with the powers of the speaker?
Madad, no, because the facts are undisputed, Madad. That's why I said these are undisputed documents. There is no political thicket here.
What you're saying is put the clock back in every which way. When you say a speaker...
Because what...
Ultimately, Mr. Sibal, it will boil down to this. You have to say that, well, if you are logically consistent, that retrace your steps to the position in which we were before the 27th of June.
That's what I said. When I argued Nabam, that's what I said, and the court accepted it. That's exactly what I said. Because you cannot, this is all staring us in the face. As I said, forget a majority, minority. Even 5 people can dislodge a government by saying that, all right, you have a trust vote now, new speaker is appointed, then every time the same thing will happen. Whereas your lordship looks at it the other point of view. If you do not, stop this menace now, it will be perpetuated. That's the other issue. I'm not saying your lordship, whatever your lordships will do, will be acceptable.
We are trying to explore that even assuming that your argument is correct, where does it lead the constitutional court to? Therefore, that's something which we would like.
There are many things you can do. Your lordships can say you decided within 7 days and you challenge the order if it's against you before us after 7 days.
Sorry, come again?
You decided within 7 days. They have not even filed a reply. Yes. Let's assume, I'm giving your lordships your options. Decided within 7 days, we are sitting here. If there's an order against you, come up and appeal and then we'll decide the matter. In fact, the speaker issued notice against us on the 8th of July. He has not even issued notice in our matter.
So to have clarity, Mr. Sibal, you say that, ask this speaker to decide the disqualification of the 39 MLAs. Ask him to do so within a stipulated period. We will then challenge. There are 2 options. If the speaker may come to the conclusion that they are disqualified, then what happens?
Then what happens?
These 39...
They will come, they will come in appeal.
No, but then what? How does that affect? What is the consequence practically in terms of the trust vote which takes place? The speaker, all right, assuming that the court has the power...
The chief minister will go.
How?
164(1)(b). He cannot hold office. One second, hold on.
39 people will go out.
And he will not be chief minister.
39 people then, if your argument is right, if the speaker holds that, they're not disqualified, Then you have a right to challenge that order before an appropriate court.
Not appropriate before your lordship.
Fair enough, whatever. If the speaker comes to the conclusion that there is a disqualification, those 39 persons go. In this case, according to Eknath Shinde also, therefore has to move out.
Yes.
Then what is the next? What is the sequel?
Nothing. Then whoever is the chief minister will get back on the trust vote. We'll see about that. This court's order on 29 said trust vote is subject to these petitions.
See, the question put to you is...
All proceedings, Manoj, all proceedings. But this is the problem, Manoj. The judicial orders are passed. We are put in this situation. Then we are asked, what can we do now?
No, we are not saying what can we do.
Yes,
we are asking what is the submission on what we can do.
No, that's what
Mr. Sibal, ultimately, you are arguing a constitutional point, but we have to also factor relief which a constitutional court then should give or is capable of granting within the format of the constitution to take the argument to its logical conclusion. So we are not for a moment saying that your argument is incorrect. What we are trying to do now is to test what are the limits of your argument.
As I told you,
how far does the court go?
Your lordship is right. That's why did I say 7 days, Manoj? Because your lordship puts it to me. Ultimately, what should be done? And I said to your lordship, all right, give him 7 days. But then the question will arise, can you issue a mandamus to the speaker to decide within 7 days? And there will be a constitutional crisis because the speaker will not obey.
That we don't know.
I don't know. It is possible. It has happened before.
Chandra is the only case where there is a direction for an early disposal of the petition. That's the only exception.
Yes.
And that again got referred to a constitution then saying that you can't direct the...
Correct. Normal, but Justice Nariman's judgment is still the same thing happened. Fundamental issue. We've challenged Mulad's decision of 3rd of July of the speaker. We are the party. That's fundamental before anything is done by the speaker. So your lordship will, my respectful, please consider the decision, then whatever the outcome is, let the outcome be.